Greetings and welcome to Presumptions, Unrebutted Inferences from Law of Evidence in American Jurisprudence. Let's get right down to the topic. So, we're getting into chapter Roman numeral 4, Presumptions, starting with the introduction, and section 181. Generally, definitions. A presumption is neither evidence nor a substitute for evidence. But before we go any further, I just want to make a note that this is strictly for the entertainment and educational purposes of this YouTube channel, broadcast only, and not to be used, misconstrued, or mispurposed for anything personal, professional, legal, lawful, business, tax, financial, or otherwise. So please don't do this at home. All right, let's get started again. A presumption is neither evidence nor a substitute for evidence. Again, we're focusing on the law of evidence here. Properly used, the term presumption is a rule of law directing that if a party proves certain facts, the basic facts, at a trial or hearing, the fact finder must also accept an additional fact, the presumed fact, as proven, unless sufficient evidence is introduced tending to rebut the presumed fact. In a sense, therefore, a presumption is an inference which is mandatory unless rebutted. So this is a great breakdown. We're going to really slice it and dice it as we get along here, but I think it's rather well laid out here that the presumption is a rule of law, right? So it becomes mandatory. It's based on a basic fact and an additional fact called the presumed fact that unless it's rebutted, right, it becomes mandatory as a fact. Again, is neither evidence nor a substitute for evidence. However, it can, it seems here, coupled with a basic fact, the presumed fact may become mandatory. Let's continue here. The underlying purpose and impact of a presumption is to affect the burden of going forward. So we saw here burden of proof previously. So the underlying purpose, the intent, and impact, so the results of the presumption, is to affect, to influence the burden of going forward, depending upon a variety of factors. A presumption may shift the burden of production as to the presumed fact, or may shift both the burden of production and the burden of persuasion, as we went over previously. So here we go with shifting the burden. Certain positions, as we saw, especially regarding criminal, that you can't really shift certain burdens. But in this case here, when we're dealing with presumptions, is to affect the burden of going forward. And depending upon the variety of factors, it may shift the burden of production as to the presumed fact, or the burden of persuasion and production. So that's the purpose of the presumption. Let's break this down a little bit more practically now. So we have here a few states have codified some of the more common presumptions in their evidence codes. Codified in their codes, of course. Often the statute will provide that a fact or group of facts is prima facie evidence of another fact. Group of facts. Courts frequently recognize this principle in the absence of explicit legislative directive, which is law. Let's see here, section 181, generally definitions, the supplement. Again, we're reading from a 1998 edition, so these are the 1998 supplements for an older text. Again, the law of evidence should not be changing significantly over time, especially regarding American jurisprudence and common law. However, there are some case authorities that do affect the practicality of the application, so that's why we do review this. CLS Family Court Act, Section 4131G, which creates irrefutable presumption imposing $25 per month floor on all child support obligations up to an accumulated debt of $500, flatly contradicts enabling legislation 42 U.S.C. Section 667 that commands opportunity in all cases to rebut and drop support award floor to $0 when impoverished circumstances so dictate. State law is thus preempted by federal statute. Gosh, good to know. We're really digging at the bottom of the barrel there. Here we have some of the footnotes. Footnote 19, inferences. Let's see, this is referring to this one here. Wow. Properly used, it's a rule of law directing that if a party proves certain facts, the basic facts, this is a good one, at a trial or hearing, the fact finder must also accept an additional fact, the presumed fact, unless sufficient evidence is introduced to rebut the presumed fact. And that comes from this here. Inferences and presumptions are a staple of our adversary system of fact-finding, since it is often necessary for the trier of fact to determine the existence of an element of a crime, that is, an ultimate or elemental fact, from the existence of one or more evidentiary or basic facts. So it's a staple of the adversary system of fact-finding, since it is often necessary for the trier of fact to determine the existence of an element of a crime. So the intention, yeah, I can see where this comes in. That is an ultimate or elemental fact from the existence of one or more evidentiary or basic facts. Interesting case here. This is County Court of Ulster County versus Allen. I guess that's Connecticut. Let's see, as a validity of mandatory inferences, see section 192. All right, we're on to section 182. Inference distinguished. Let's jump over here to the chat, make sure we're all up to date here. Seems like we got some pretty thin notifications. Please hit the like if you're here to make sure that anyone that didn't get notified still might find it in their feed. And greetings to you, audit them. Let's continue. An inference is a factual conclusion that can rationally be drawn from other facts. Inferences are by their nature permissive, not mandatory. Although the fact proved rationally supports the conclusion of the offering party hopes will be inferred, the fact finder is free to accept or reject the inference. In deciding whether an evidentiary device is permissive or mandatory, this evidentiary device, two factors are paramount: the scope of the inference or presumption and the precise presentation of the presumption to the jury. A presumption's scope includes the statute creating the presumption itself, cases interpreting the presumption, and an evaluation of the probability of the presumed or elemental fact existing upon proof of the basic fact. So evaluation of the probability of the presumed or elemental fact existing upon proof of the basic fact. So here we have an evaluation of probability as opposed to a proof. The jury instructions will also generally be controlling in determining whether an inference will be classified as permissive or mandatory. This is a good breakdown. As you see, we're really splitting hairs here. Let's see what we have in the footnotes, any further detail. Just citations. Using the word permissive with the word inference is redundant. since there are no mandatory inferences. Good usage advice here. Forms. Instruction to the jury. Effect of failure to rebut inferences. Wow. And here's instructions on inferences drawn from failure to produce evidence. This is a good one. This is from evidence and forms and the pleading and practice forms. Nice. A jury was specifically told that the statutory inference that presence at a still indicated criminal activity in connection with the still was not conclusive, but was merely one circumstance to be considered. Yeah, because sure, why not hang out by the still? On the other hand, an instruction to the defendant's presence at the still shall be deemed sufficient evidence to authorize a conviction, impermissibly authorized a conviction, even if the jury disbelieved all the testimony except the proof of presence at the site. Instruction the defense presence shall be deemed sufficient evidence to authorize a conviction, impermissibly authorized. To authorize a conviction impermissibly authorized. These, when they abbreviate these citations here, it's hard reading. One more time. On the other hand, an instruction that the defendant's presence at the still shall be deemed sufficient evidence to authorize a conviction, impermissibly authorized a conviction, even if the jury disbelieved all the testimony except the proof of the presence at the site. So that one thing was enough to impermissibly authorize a conviction. Okay. Yeah, it'd be nice if they stuck another word in there, maybe with a comma. Okay. We're on to section 183. In criminal cases under Rule 303, of the Uniform Rules of Evidence, basic facts create, at best, only an inference from which a presumed fact may be determined at the jury's discretion. But the presumption cannot be compelled at the judge's direction in a criminal case. Thus, such a rule has the effect of reducing presumptions in criminal cases to nothing more than permissible inferences when used against an accused. That's an interesting take right here, right? The presumptions, nothing more than permissible inferences. Such an evidentiary device cannot relieve the state of proving all elements of a crime, and a judge is not authorized to, in effect, direct a partial verdict against the accused on the issue. According to Rule 303, a court is not directed to find a presumed fact against the accused in a criminal case. If a presumed fact establishes guilt or is an element of the offense or negatives a defense, the court may submit the question of guilt or of the existence of presumed fact to the jury, but only if a reasonable juror, on the evidence as a whole, including evidence of the basic facts, could find guilt or the presumed fact beyond a reasonable doubt. So we went over a lot of this on the last one, how this all applies in the criminal situations. If a presumed fact establishes guilt or is an element of the offense or negatives a defense, the court may submit the question of guilt or of the existence of the presumed fact to the jury, but only if a reasonable juror on the evidence as a whole, including evidence of the basic facts, remember these have to be proven, could find guilt or the presumed fact beyond a reasonable doubt. So that's who's deciding that? Only if a reasonable juror. If the presumed fact has a lesser effect, the question of its existence may be submitted to the jury, provided that the basic facts are supported by substantial evidence or are otherwise established proof, unless the court determines that a reasonable juror on the evidence as a whole could not find the existence of the presumed fact. So I guess the court decides that. That's a slippery situation right there. footnote 34. Let's take a look at that real quick. Uniform Rules of Evidence 303B. So, whenever the existence of a presumed fact against the accused is submitted to the jury, the court is required to instruct that the jury may regard the basic facts as sufficient evidence of the presumed fact, but is not required to do so. In addition, if the presumed fact establishes guilt, it is an element of the offense or negatives a defense. The court is required to instruct the jury that its existence on all the evidence must be proved beyond a reasonable doubt. The rule described above applies, except as otherwise provided by statute, with regard to common law and statutory presumptions against the accused, including statutory provisions that certain facts are prima facie evidence of other facts or of guilt. So, this rule here is very important. If a presumed fact establishes guilt, is an element of the offense or negatives a defense, the court is required to instruct the jury that its existence must be proved beyond a reasonable doubt. High bar there. The rule described above applies except as otherwise provided by statute with regard to common law and statutory presumptions against the accused, including statutory provisions that certain facts are prima facie evidence of other facts or of guilt. Thus, even if it is a common law presumption in tort cases that one who is speeding is negligent, the rule has the effect that this presumption, at best, creates only an inference in a criminal case. Wow. The rule's language that a statutory provision dealing with prima facie evidence establishes a presumption that also indicates that the rule governs the effect of such statutes as those providing that the proof of unlawful possession of a controlled substance is prima facie evidence of knowledge of its character. Wow. Establishes a presumption indicates the rule that governs the effect of such statutes as providing that the proof of unlawful possession of a controlled substance is prima facie evidence of knowledge of its character. Wow. Geez, State versus Rainey, Oregon. Nice. All right, so we're on to section 184. Conclusive presumptions. Getting a little of the Esquire talk here. A conclusive or irrefutable presumption is not a presumption at all. It is a substantive rule of law directing that proof of certain basic facts conclusively proves an additional fact which cannot be rebutted. Such presumptions rest upon grounds of expediency or public policy, so compelling in character as to override the requirement of proof. Okay, so we have a supplement for section 184, conclusive presumptions. Here's some case authority. The trial court did not err in a sentencing hearing for first-degree murder by submitting evidence of a prior attempted rape conviction, submitting the aggravated circumstance of a prior felony involving violence, or its instructions where the state submitted evidence that the defendant had been convicted by general court-martial of attempted is a felony under North Carolina law, as well as under military law. And since the military courts have held all of them to be crimes of violence under military law, and all attempts to commit it, therefore, by definition, involve use or threat of force, there is no need to consider whether it is a nonviolent crime of attempted under North Carolina law. The evidence presented concerning the prior felony was proper and sufficient to establish that the defendant had been convicted of a prior felony involving the use or threat of violence to the person, and the court's instruction did not constitute an impermissible conclusive presumption. There we go. Impermissible conclusive presumption, as it permitted the jury to make the determination as to whether the defendant had been convicted. Interesting. All right, well, there it is. Nice technicality. So, as I said, these are the good Esquire talk here. A conclusive or irrefutable presumption is not a presumption at all. It is a substantive rule of law directing that proof of certain basic facts conclusively proves an additional fact which cannot be rebutted. So this becomes mandatory, right? Such presumptions rest upon grounds of expediency or public policy, so compelling in character as to override the requirement of proof. See footnote 40. Do we see that one? United States versus Provident Trust. All right, that's it for the details in the footnotes. Let's get on to section 185, rationale. Let me double check over here to the chat. I wonder if there's anyone even in the room. Anyone pipe up in the chat would be great. I'm not sure it's even showing up here. I should probably refresh it. There we go. All right, yep, I needed to refresh here. Greetings, Craig Carey. All right, this is a real important one here. All right, good. All right, so we're still on. We're live. And Bill Thomas, greetings. All right, so we're on to rationale. Rationale, section 185. Most presumptions are based, at least in part, on the high probability that if the basic facts exist, the presumed fact also exists. Well, a high probability. The presumed fact is so likely to follow from the basic fact that in the absence of rebutting evidence, merely permitting the fact finder to infer the presumed fact does not adequately reflect the substantial likelihood that the presumed fact is true. Presumptions are sometimes created to offset one party's advantage or disadvantage with regard to availability of proof. For instance, evidence that the shipper delivered the freight in good condition to the first of several carriers triggers a presumption that the damage was caused by the last carrier. Similarly, in certain securities fraud actions, once plaintiffs prove omissions or misrepresentations by the defendants, a presumption exists that the plaintiff relied on these omissions and misrepresentations to its detriment. Wow. Presumptions sometimes serve the purpose of facilitating the resolution of factual disputes that otherwise might not be capable of decision. For instance, the presumption that someone who has not been seen or heard of for 7 years is dead. 7 years dead. That's a presumption? Okay. Courts and legislatures also create presumptions to implement social policy by assisting one class of litigants against another. Wow. Class of litigants. Social policy. Wow. 45. Keys versus school district. Yeah, okay. On remanded. That was in D.C. Was it District Court of Colorado? Or no, is that what it is? All right. That looks like a terrible, some terrible cases there. All right. Section 186. Choice of law. Remember, we're on with presumptions still. States have taken a variety of approaches to applying choice of law principles to burdens and presumptions. The traditional approach to choice of law issues applies to the law of forum state in all procedural matters, while applying applicable foreign law as to substantive matters. Because presumptions and burdens of proof are perceived as procedural rather than substantive, They are governed by the law of the forum. So, presumptions and burdens of proof are procedural rather than substantive. So the law of the forum is what governs them. Now that's interesting there, and that's important to take note. When the law of a foreign state on burdens of proof or presumptions is inseparably connected to the substantive right in question. Wow. Wow, this is an important one too, especially if you get back to the presentation on the Treaty of Friendship between Morocco and the United States of America. It's inseparably connected to the substantive right in question, or is intended to affect the substantive rights of parties, and does not violate the public policy of the forum state. The law of the foreign state, rather than that of the forum, governs. We've got to look at that footnote here. 48. Oh my gosh. Look at all these cases. Wow. Bueller versus Madison. Whole bunch in here. Greyhound lines. Bus lines. All right. So interesting stuff on that one. Wow. That's a... Wow. Look at all the footnotes on these. This section here. When we're talking about presumptions, this is where the rubber really hits the road. Let's see here. Let me jump over here to the chat real quick. Really hitting into the deep end here. Law of the forum is essentially the venue you're in. So if you're in a state court, but it's litigating a contract based on laws from somewhere else, then I think that's what they're referring to here. Treaties too would apply. The treaties, those laws would supersede law of the forum, but you might be tried in a local or a closer forum. I'm not positive on that, but that's what it seems to me when they talk about this, because it's a law of a foreign state on burdens of proof is inseparably connected to the substantive right in question. So that could be contractual or otherwise. It is intended to affect the substantive rights of parties and does not violate the public policy of the forum state. So if the public policy of the forum state is to accept foreign treaties that it signed, then it wouldn't violate that. The law of the foreign state rather than that of the foreign state rather than that of the forum governs. The contact approach applies to the law of the state, which is the most interested in the outcome of the particular question of law. A third approach provides that the forum will apply its own local law in determining which party has the burden of persuading the trier of fact on a particular issue, unless the primary purpose of the relevant rule of the state of the otherwise applicable law is to affect the decision of the issue rather than to regulate the conduct of the trial. Whoa, so it's about the decision rather than the conduct of the trial. So the relevant rules, local laws, all that persuasion of the trier of fact seems like this third approach here will apply its own local law. And it has here on the, let's see here. Unless, there it is, unless a primary purpose of the rule, the relevant rule, which might not be the local rule, of the state of the otherwise applicable law, I think that's what they're saying here, is to affect the decision of the issue rather than regulate the conduct of the trial. So if it's to the substantive issue rather than the conduct of the trial or the procedure, I think is what it would mean. It would be overriding. Whew, it's really getting deep with trying to follow along with some of this language here, but they do repeat it in a nice way to keep it, so that it eventually sinks in. And I think that's a good thing about the particular redundancy of American jurisprudence. Regardless of a state's approach to choice of law, again, we're just speaking about choice of law here. Courts, as a rule, recognize that conclusive presumptions affect the substantive rights of the parties. Thus, where the substantive law is applied by a foreign state, let me read this again because the N and the M get confused. Thus, where the substantive law is supplied by a foreign state, the forum state will apply the former's conclusive presumptions. That's the foreign state's conclusive presumptions. So that's a good tongue twister there. The foreign state and the forum state. Who would think? And here's our extensive list of footnotes. Where the burden of proof has a substantive impact as to affect the decision of the case, or is intertwined with a statutory remedy. The burden of proof is deemed substantive and should be determined according to otherwise applicable law. So lots of hair splittings going on here. Let's see here. We're not going to read that one there. Let's see this one here. In a wrongful death and products liability action brought in Oklahoma against businesses located in Michigan, Ohio, and Florida concerning an accident in Colorado, Oklahoma's interest in compensating the survivors justified application of Oklahoma law on burden of persuasion because the van was put into the stream of commerce in Oklahoma. Plaintiffs and descendants were Oklahoma residents, and defendants did business in Oklahoma. Wow. One more time. Wrongful death and products liability action brought in Oklahoma against businesses located in Michigan, Ohio, and Florida. And it was concerning an accident in Colorado. Oklahoma's interests in compensating were justified application of Oklahoma law. Interesting. Okay, in holding that California law applied as to a presumption of motor vehicle ownership, the court gave some consideration to the fact that California was the state in which plaintiffs were injured, as well as the state in which the forum was located. Presumption of motor vehicle ownership. Okay. Let's see, this one here was remanded. Contacts with District of Columbia were superior to those of any other jurisdiction, such that the District of Columbia law governed. Wow. Wow. Well, something to note here with the great District of Columbia United States Corporation here, huh? Don't mess with them. Superior to any other jurisdiction. All right. Speaking of which, we're on to Section 187, Federal or State Law. Rule 302 of Federal Rules of Evidence provides that in civil actions and proceedings, the effect of a presumption respecting a fact which is an element or a claim or defense, an element of a claim or defense, as to which state law applies the rule of decision, is determined in accordance with the state law for choice of law purposes. This is federal or state law. A presumption which supplies a fact which is an element of a claim or defense, or which affects the decision of the issue, is substantive, and if state law provides the substantive rule of the decision, the forum state's conflict of laws rules determine what substantive law applies, and the presumptions that go with it. Rule 302 does not, however, apply to mere inferences. Well, good thing we have a comment here. State law usually applies in diversity cases, but this designation is not completely accurate since the Erie Doctrine applies to any claim or issue having its source in state law. Hey, Erie Doctrine, regardless of the basis of federal jurisdiction, and does not apply to a federal claim or issue even though jurisdiction is based on diversity. Hence, Federal Rule of Evidence 302 employs the phrase, as to which state law supplies the rule of decision. That's 55. Let's see what that is here. Advisory committee knows, of course, that advisory committee. Rule 302 applies to presumptions that involve a fact which is an element of a claim or defense, such that the presumptions that a descendant was exercising due care or against, On the other hand, it does not apply to a tactical presumption where such is not an element of the plaintiff's case. Uniform rules of evidence conversely provide that in civil actions and proceedings, the effect of a presumption respecting a fact which is an element of a claim or defense, as to which federal law supplies a rule of decision, is determined in accordance with a federal law. So if the rule of decision is federal law, then it's determined in accordance with federal law in civil actions. Effect of a presumption respecting a fact. So, as to when state law provides rule of decision, see Federal Practice and Procedures, Section 267 there. Okay. Many states' versions of the uniform rules omit this provision. What provision's that? Variations from official text. All right, now we're on to a good one here. Bill Thomas says inferences sound like an interesting subject by itself. Indeed, as we're saying here, there's distinctions between simple inferences and presumptions too. There was a clarification earlier in the presentation too, where it went over that. Let's see. We had a section here, I know, where we had the difference between, here we go. So, in a sense, a presumption is an inference or an educated guess, which is mandatory unless rebutted, right? And we also had the fact that, let's see here. We had another clarification too, an inference distinguished. There it is. An inference is a factual conclusion that can rationally be drawn from other facts. Inferences are by their nature permissive and not mandatory, although the fact proved rationally supports the conclusion of the offering party hopes will be inferred. The fact finder is free to accept or reject the inference. So, that's where the inference comes into it. The scope of the inference or presumption and the precise presentation of the presumption to the jury. So, permissiveness, mandatory, and jury instructions will be controlling and determining whether an inference will be classified as permissive or mandatory. So, that's a pretty good good clarification there, at least in this context here of inference. All right. So we're on to the administrative presumptions, section 188. Administrative presumptions must satisfy a test of logical probability. This appears to be a somewhat more demanding test than the sum rational connection test enunciated for legislative presumptions. Than the sum rational connection test. So this is a test of this is the logical probability test as opposed to the sum rational connection test. An administrative presumption's usefulness, to the degree to which it is needed to further the reasons underlying its creation, the creation of that presumption, are relevant to its considerations. Usefulness, reasons for its creation. Its intent, the maxim behind it. It's relevant to its consideration. Beautiful. Something to really note, because most of the presumptions that we'll encounter in our day-to-day legal interactions seem to be administrative in nature. And by seeing that the administrative presumption's usefulness and degree which can further the reasons underlying its creations, right? It is needed to further the reasons underlying its creation. So this is the intention for the presumption, and it's relevant to its consideration. An assessment of factual probability. That's one for the checklist. Usefulness, another one. And necessity, a third one. Is it needed? Is sometimes implicit rather than explicit, but these remain significant considerations. To be constitutional, a presumption must afford a party a fair opportunity to rebut it. Wow. So a very succinct section here, 188, administrative presumptions. And I love the way it closes here. To be constitutional, a presumption must afford a party a fair opportunity to rebut it. That's footnote 64. There it is right there. Strong versus K&K Land Management Incorporated in Florida. And the Department of Health and Rehabilitative Services in Florida as well. So this is nice. This was, wow. Good stuff here. Let's see what else we have here. A lot of Florida cases, it seems, regarding administrative presumptions here. 60 is the test of logical probability. That's the Baptist Hospital one there on remand, later proceeding. Presumptions promulgated by the, what's this, NLRB, must have a sound factual connection between the basic and presumed facts. Remember this. You need to have both the basic facts and the inference leads to the presumed fact. And there has to be a factual connection, a sound connection, factually. All right, let's see here. Footnote 161 was the some rational connection test for discussion on the constitutional issues present with legislatively created presumptions. See section 190, which we'll be at shortly. Excellent. Here's that case again with Baptist Hospital, Livestock Ranch versus United States. A presumption cannot be used to prove the act of trespass itself, because the presumption was not necessary to prove trespass. Wow, this is a nice one right there. Later proceeding, some actual trespass had been proved. A presumption could be used in measuring damages caused by grazing, because demonstrating each individual trespass would be extremely difficult, if not impossible. Oh gosh. Holding valid that the National Oceanic and Atmospheric Administration's presumption that if 3 1-pound samples taken from a multi-hundred-pound catch of scallops failed to satisfy size and weight standards, the entire catch violated the standards, despite the petitioner's claims that the presumption was irrational because the size of the sample is statistically insignificant. Failed to satisfy. Wow. That stood. Well, I would say that perhaps they didn't have the right expert witnesses here dealing with sample size and statistical significance, because there is certain industry standards on that, which are remarkable and involve pretty advanced mathematics behind them. And I would doubt that the any government agency would do it. Anyways, I digress. All right, we're on to section 189 in the applicability of Rule 301. There's a split of authority as to whether or not Rule 301 of the Federal Rules of Evidence, providing that a presumption does not shift the burden of proof, applies to regulatory and administrative hearings and trials. Some courts holding the rule applicable to such proceedings, while others hold that such proceedings are not civil actions and proceedings as meant by Rule 301 because they do not fall within Rule 1101, which defines the proceedings to which the federal rules of evidence apply. Okay, where Congress explicitly directs the federal rules of evidence should apply to such proceedings, however, Rule 301 is applicable. Assuming the rule applies to such proceedings, courts are divided as to whether presumptions created by regulatory agencies and used in agency proceedings are subject to Rule 301. We went over this too when we were dealing with another topic here on the channel. I'm trying to remember which one, but it did go, and I think it was the Administrative Act. All right. Find that on the miscellaneous playlist, I believe. Here we go. Rule 301 did not limit the effect of the so-called presumption of propriety of a bargaining unit because the presumption was a substantive, not a procedural presumption, such as set forth in Rule 301. See, a union represents a majority of its members. Does not apply to National Labor Board. Okay, labor. Okay. Let's see. Black lung specifically authorize an official or agency to create presumptions is a provision which otherwise provides within the meaning of Rule 301. Wow, interesting there. All right, well, that takes us on to Section B, which is constitutional issues affecting the validity of presumptions. And it starts out with civil litigation, Section 190. But this will be for the next episode because we're leading up to this. We just went over a pretty dense section here on presumptions, and we're still continuing with them as we get into the civil litigation aspects of presumptions, now that we've gone over the general applications of it, and now the constitutional issues affecting the validity of presumptions. Jump over here to the chat and make sure we're all refreshed and up to date. Indeed, and I hope we covered inferences to your satisfaction there, Bill Thomas. It was a good suggestion here to make sure we had that clarified. And I know it's been pretty thin on the notification, so many people may have got here a little bit later than expected. And appreciate the comments and also the enthusiasm for everybody that has been sticking with it. As we go deeper down in the law of evidence with presumptions now, and as we see here, the unrebutted inferences that are derived from basic facts become the presumed facts and entered in as presumptions, which still are not evidence per se, but can have the effect of persuasion, shifting burdens, and other factors that will affect ultimately how the evidence is presented to a jury or the fact finder, so it be. With that said, I'd like to thank everyone for showing up and hope to see you all on the next one. Peace out.